And with respect to judicially discoverable and manageable standards, the Texas Supreme Court explained in its Neely decision, the judiciary is well accustomed to applying substantive standards, the crux of which is reasonableness. So not only can the courts adjudicate such cases, they already have. And in this case, plaintiffs are simply asking for this court to do what the highest courts of 18 sister states have already done, which is to use the tools of constitutional interpretation to determine what the legislature's affirmative constitutional duty is, and then weigh the factual evidence to determine whether it is fulfilling that duty. To make this a little bit more concrete, I would point the court to the example of the New York Court of Appeals in the CFE line of cases. There's also an amicus brief on this issue that the court to look to for other ways the CFE case parallels our own. The court in CFE used a kind of three-step inquiry, which could serve as a model to adjudicating plaintiffs' claims in this case. First, using a Geisler-type analysis, constitutional analysis, the court determined the constitutional purposes and goals of public education according to their education clause. And they found those to be to prepare students to, quote, function productively as civic participants and, quote, compete for jobs that enable them to support themselves. These are the same claims that we raise in our complaint. Second, the court made a factual inquiry into what levels of educational attainment are necessary in a contemporary society for these purposes to be met. And to do this, the court in CFE looked to expert testimony, looked to the statements of the court, looked to statements from the legislature, the Department of Education, and there was broad consensus of the types of levels of educational attainment necessary for students to be effective citizens and to compete in the economy. And then third, the court used a totality of the circumstances analysis, akin to Horton's 8-factor inquiry, to determine as a factual matter whether the state was providing the kinds of financial and educational resources necessary for students to have the opportunities to reach these levels of attainment and graduate prepared to be effective citizens and to compete in the global economy. Another question for consideration is whether this court should even reach the question of whether or not there are judicially discoverable and manageable standards at this early stage before the presentation of any evidence. Indeed, we believe that the question of whether a trial court can, after reviewing a full factual record, develop such standards is a question that is best left to the trial court in the initial instance, rather than determined ex ante in the abstract prior to the presentation of any evidence. Reliance on these kinds of hypothetical concerns or abstract conjecture that the state may raise to answer this important question, we believe is both unnecessary and unwarranted. It's unnecessary because the court may continue to challenge this question of judicially discoverable and manageable standards at any point in the trial, whether after summary judgment or after the trial itself. And if the trial court is unable to find such standards, or plaintiffs are unable to show that such standards exist, they could prevail at that point, and it's not necessary to reach that question at this point. In short, we don't believe that the court should accept the state's invitation to rush to judgment on this question before factual development has been made. Unless the court has further questions, I would like to reserve the remainder of my time to rebut the state's affirmative presentation. And I'll just sum up with a few words. Based on the longstanding precedent of this court and the overwhelming majority of sister state decisions, we believe the trial court was clearly correct in finding plaintiffs' claims justiciable. Furthermore, the question of whether plaintiffs present judicially discoverable and manageable standards, as I said, we believe is best decided by the trial court after a full factual hearing rather than in the abstract, this early stage. As the court stated in CCJEF, using the strongest possible language it could and considering the very complex factors that are part of determining this question of racial segregation, the court noted that a denial of constitutionally protected rights demands judicial protection. We believe that the affirmative constitutional rights of plaintiffs in this case deserve no less, and as such, the court should reject the state's invitation to forever close its doors to plaintiffs' claims. Thank you.
Counsel, you have not only this time, but the time that was reserved
Yeah,
prior also.
Thank you.
Good morning, Your Honors. Justice Norcott, members of the panel. May it please the Court. Gregory Doria from the Attorney General's Office, along with Assistant Attorneys General Claire Kindle and Robert Dykert, representing the defendants. I'd like to, I think Justice Zarella put his finger on it in his queries of plaintiff's counsel about the use of the term appropriate and the use of the language from CCJEF. The plaintiffs really seek to use the term appropriate in the second sentence of Article 8, Section 1, and the court's statement in CCJEF as a hook to create an unenumerated right in the constitutional text, from the constitutional text, to some sort of a qualitative determination of education. And this case, although the plaintiffs concede that this is a much different case than CCJEF, they seem to indicate that the statement in CCJEF stands for all time, that all Article 8, Section 1 cases are going to be justiciable. And really, that's not the case. First of all, that goes against the principle that justiciability is determined on a case-by-case basis.
Mr. Doria, can I interrupt just for 1 second? I just have a threshold question.
Sure.
I want to understand your claim on justiciability. Is it your view that if for some unforeseen reason the state decided to stop funding schools and allowed towns to just essentially shut down their schools, or allowed a town to shut down its schools, that the affected students in that school or those schools would have no recourse judicially?
That's not our claim. I believe there could be a set of standards, a set of facts under which, if there were no schools, the constitutional right is to free and public schools. If there were no schools, that could be a justiciable claim. The quality of those schools, implementing that principle of free and public schools and determining their quality is a question for appropriate legislation by the legislature. That is textually and demonstrably committed.
But whether a school, whether the state provides schools or provides funding for schools is an entirely different matter that's non-justiciable.
Whether they do, I think if I understand Your Honor's question, that would be justiciable if the state were not providing schools. That would be justiciable, I believe. I believe then you would look to the first sentence of Article 8, Section 1 and say the right, and it's important under your case law to define the right. The right is to free public schools. Through the Equal Protection Clause, to an equal educational opportunity, substantially, to enjoy that opportunity. That's a trial and proceedings that apparently will go on the third count in this case. Is everybody enjoying that right equally? That's what courts do. Courts are best equipped to do that in measuring equality. Quality, in and of itself, number one, courts are not well equipped to do quality in a vacuum. I think this court would be very hesitant to arrogate to itself the authority to determine and enforce what the quality standards should be of these schools unless there was some precise language, I'm quoting from your own cases, textually precise language that commits that to the courts.
Mr. Doria, let me ask you a more seminal question for my purpose. What does a fundamental right to education mean without some qualitative component?
It means the fundamental, again, your cases have say that you have to ask the question precisely, what is the fundamental right? It's not just the fundamental right to education, but to a school and to the equal opportunity to enjoy that education compared to the rest of the children going to school. And that is the check, Your Honor. That is the check on a democratic process, unless we fear that all school children...
That means that the fundamental right is satisfied in a poor city juxtaposed to a wealthy city, and the children therein.
It is not if they can prove that they are not receiving an equal educational